So you've been in an accident in California. You just got off the phone with an insurance adjuster. They were friendly, almost too friendly. They told you they have reviewed your file, they understand what you've been through, and they're ready to make it right. And then they threw out a number, and now you're sitting there wondering, is that a fair offer? Should I take it? Or am I about to make one of the biggest financial mistakes of my life? If that's you right now, stay with me, because in the next 20 minutes, I'm going to walk you through exactly what you need to know to make that decision. We're going to talk about how insurance companies actually operate, what California law says about your rights, when you generally don't need a lawyer, and when going it alone could cost you tens of thousands of dollars. My name is Steve Sweat. I'm a personal injury attorney here in Los Angeles, and I've been doing this for 30 years. I'm not here to sell you on hiring a lawyer. I'm here to give you the honest information you need to make the right call for your situation. So let's get into it. Before we talk about whether you need a lawyer, you need to understand something really important about the process you've just entered. When you file a personal injury claim in California, you are not just filling out paperwork and waiting for a fair check to arrive in the mail. You are entering an adversarial process. That word adversarial matters. It means the other side has interests that are directly opposed to yours. The insurance company, which is often a multi-billion-dollar corporation, has an entire team. They've got adjusters, lawyers, investigators, medical reviewers. Their job every single day is to figure out how to pay claimants as little as possible. That's not a conspiracy theory. That's just how the business model works. Now, that doesn't mean every insurance company is acting in bad faith. Most of the time, they're operating within the law, but the system is built in their favor. And if you don't know the rules, you will lose. Here's what their actual playbook looks like. These are tactics that insurance adjusters are trained to use. Not illegal, but absolutely designed to minimize what they pay you. Number one, they call you fast, often within 24 to 48 hours of the accident, before you've had a time to see a doctor, understand your injuries, or talk to an attorney. Why? Because they want to lock you into a conversation, maybe even a recorded statement, before you know what your case is worth. Number two, they ask for a recorded statement, make it sound routine. It is not routine. It is a professional interview designed to get you to say something that minimizes your claim. Something as simple as, I'm doing okay, can be used to argue against you later that your injuries weren't that bad. Number three, they dispute your injuries. They'll suggest your injuries were pre-existing. They'll question whether the accident really caused your back pain. They'll say you didn't follow your treatment plan. Every gap in your medical records is an opportunity for them. Number four, the early lowball offer. They make you a quick offer often before you know the full extent of your injuries, hoping that the financial pressure pushes you to take it. And once you sign that release, and there will be a release, your claim is over forever. Number five, they play the clock. They know California has a 2-year statute of limitations on personal injury claims. If they can, they'll drag things out long enough that you panic about the deadline. You become much more willing to settle for less. None of these tactics are illegal, but they are effective, especially against people who are dealing with real pain, real bills, and real stress, and who don't have experience with this process. That's the environment you're navigating. All right, let's talk about the actual legal framework in California, because this stuff matters a lot, and most people don't know it. The statute of limitations in California is generally 2 years from the date of your accident. So in other words, you have 2 years to file a lawsuit. If you miss that deadline, and your case is almost certainly gone forever. It doesn't matter how severe your injuries were. It doesn't matter how clearly the other driver was at fault. The clock runs out, your claim dies. But here's the wrinkle that trips people up. Your accident involved a government entity, a city bus, a pothole on a public road, a government employee driving a county vehicle. Deadline isn't 2 years. It can be as short as 6 months. 6 months to file a formal government tort claim, or you lose the right to sue entirely. I've seen people wait a year before calling an attorney thinking they had plenty of time, only to find out the government claim window has already closed. That is a devastating situation to be in. If there's any chance a government entity was involved in your accident, you need to talk to a lawyer immediately. Next, let's talk about California's comparative fault rule. California follows what's called a pure comparative fault rule. Here's what that means in plain English. Even if you were partially at fault for your accident, you can still recover damages, but your award gets reduced by your percentage of fault. So if a jury determines your total damages are, let's say, $100,000, but you were 30% at fault, you walk away with $70,000. That's the law. Insurance companies know this rule inside and out, and they will work aggressively to push your fault percentage as high as possible. Every degree of fault they can shift to you is money they don't have to pay. Without an attorney pushing back on that, the fault assessment often goes unchallenged, and you pay the price. So let's talk about what damages you can actually recover. This is where a lot of people massively underestimate the value of their case. California law allows you to recover a much wider range of damages than most people realize. We're talking about your past medical bills, the treatment you've already received, your future medical expenses, treatment you'll need down the road, lost wages, time you've already missed from work, loss of earning capacity if your injuries affect your ability to work going forward, pain and suffering, real compensable damages for your physical pain you've experienced, emotional distress, the psychological impact of the accident and your injuries, loss of enjoyment of life, if you can no longer do the things you used to do, and in cases of extreme recklessness or misconduct, punitive damages. Here's the critical thing. Calculating future medical costs and lost earning capacity requires expert witnesses, economists, medical professionals, vocational specialists. These are resources that unrepresented claimants almost never have access to and almost never even think to ask for. Okay, I want to be straight with you here because I think it's important that this isn't just a sales pitch for hiring a lawyer. The truth is, not every personal injury situation requires an attorney. There are genuinely cases where handling things yourself is a reasonable approach. If you were rear-ended, suffered only minor soft tissue injuries, got a few weeks of treatment, and you've fully recovered, and the liability is completely undisputed, you may be able to negotiate a reasonable settlement on your own. Insurance companies are more willing to settle minor, clear-cut cases fairly because the cost of litigation isn't worth it to them. If your only loss was property damage, no personal injury, the process is more straightforward. You're dealing with repair estimates and a rental car reimbursement. Those are concrete numbers, hard to manipulate significantly. And if you have the time, the patience, and the organizational skills to gather your medical records, draft a demand letter, and go back and forth in negotiations, you can potentially navigate a minor claim yourself. But here's the caveat. I want you to really hear this. Injuries that seem minor right after an accident can turn into something much more serious within days or weeks. Whiplash, for instance, often doesn't fully develop until 24 to 72 hours after a collision. A back injury that felt like soreness on day 1 can become a herniated disc diagnosis at week 3. If you settle before you fully understand the extent of your injuries, and I mean fully, as in you've reached maximum medical improvement, and then it turns out your injuries are worse than you thought, you have no recourse. You signed a release. Your claim is done. That's a mistake that can't be undone. So even in cases where you might handle the claim yourself, please do not sign anything until you know exactly what you're dealing with medically. Now let's talk about the situations where going it alone is a serious mistake. I'm going to give you 7 clear scenarios. If any of these apply to you, please call an attorney. And I mean that regardless of whether you call my office or someone else's. Number 1, your injuries are serious or long-term. If you were hospitalized, if you had surgery, if you have ongoing treatment, if there's any question of permanent disability, chronic pain, or a lasting limitation on your ability to work or live your life, the value of your case is almost certainly far greater than any early offer. These cases require expert witnesses. They require legal strategy. They are not DIY situations. 2, liability is being disputed. If the other party's insurance company is saying you were at fault, fully or partially, you need an attorney. Investigating accidents, preserving evidence, obtaining surveillance footage, interviewing witnesses, working with accident reconstruction experts, that's what attorneys do. That's not something most people have the tools or knowledge to do on their own. 3, multiple parties are involved. Accidents involving a commercial truck driver, a rideshare vehicle, a defective product, a government vehicle, or multiple cars, these are legally complex. There are multiple insurers, multiple policies, questions about coverage and liability allocation. This is not territory for the uninitiated. 4, the insurance company is acting in bad faith. If the insurer is denying your claim without justification, refusing to communicate, making absurdly low offers, or dragging their feet past any reasonable time frame, they may be acting in bad faith. California has strong bad faith statutes. You may be entitled to damages beyond your underlying injury claim, but you need an attorney to assert those rights. 5, you've already received a settlement offer. If the insurance company has already called you with an offer, that is a signal. It means they believe your claim has genuine value and they want to close it out cheap before you know what it's really worth. Before you accept a single dollar, have an attorney look at it. Most offer free consultations. One conversation could reveal whether that number is reasonable or whether you're being lowballed by 50, 60, 70%. 6, your ability to work has been affected. Lost wages is one thing. Lost earning capacity, the long-term impact on your ability to earn a living, is something much bigger. If your injuries have impaired your ability to do your job either now or going forward, proving that requires economic experts and vocational assessments. Attorneys arrange this routinely. Unrepresented claimants almost never even know to ask for it. If you've lost a family member because of someone else's negligence, California's wrongful death laws allow you to seek compensation for funeral expenses, loss of financial support, and loss of companionship. These cases are among the most legally complex matters in personal injury law. Please do not navigate this alone. You're already dealing with grief. You deserve someone fighting for you. I know what some of you are thinking. Sure, you're a lawyer. Of course, you're going to say I need a lawyer. So let me take myself out of it and just show you what the data shows. A widely cited study by the Insurance Research Council, not a plaintiff's attorney group, an insurance industry research organization, found that injury victims who hired attorneys received settlements that were, on average, 3.5 times larger than unrepresented claimants. 3.5 times. And that is before attorney's fees. After deducting a standard contingency fee of 33%, represented claimants still walked away with significantly more money than those who handled things on their own. Why the gap? A few reasons. Attorneys know the full scope of damages and fight for all of them, not just the easy ones. Attorneys have access to medical and economic experts. Insurance companies know that attorneys will litigate, and litigation is expensive, so they negotiate differently when there's an attorney on the other side. And attorneys know what similar cases have settled for in your jurisdiction, so they negotiate from a position of actual knowledge. And here's the part I want you to really sit with. Personal injury attorneys work on a contingency. That means you pay nothing up front. You pay nothing out of pocket. Your attorney only gets paid if and when you recover money. If you don't win, you owe nothing. In what other professional context do you get that kind of guarantee? Before we get to the practical next steps, I want to run through 5 mistakes that I see unrepresented claimants make all the time. Some of these are devastating. Most of them are completely avoidable. Mistake number 1, giving a recorded statement. The adjuster calls and says it's just routine. It is not. They are trained interviewers gathering material to minimize your claim. You are generally not required to give a recorded statement to the other party's insurance company. If you've already given one, it's not necessarily fatal, but you should not do anything further without talking to an attorney first. Mistake number 2, settling before your injuries are fully known. This is the big one. Once you sign a release, your claim is over. No matter what happens medically after that point, you have no recourse. Wait until you've reached maximum medical improvement, until your doctors can tell you what your long-term prognosis looks like before you even think about settling. Mistake number 3, ignoring non-economic damages. Pain and suffering, emotional distress, loss of enjoyment of life. These are real, legitimate, legally recoverable damages in California. They can be worth more than your medical bills in serious injury cases. Unrepresented claimants almost universally leave money on the table. Mistake number 4, missing deadlines. California's statute of limitations is not forgiving. Neither is the 6-month window on government claims. If you miss a deadline, your case is gone. An attorney tracks these dates obsessively. That's part of what you're paying for. Mistake number 5, not identifying all available insurance coverage. Your own uninsured or underinsured motorist coverage, umbrella policies, commercial vehicle policies. If you were hit by an Uber or a Lyft driver, there may be up to $1 million corporate policy in play. Identifying and pursuing all available coverage requires legal knowledge. Most unrepresented claimants leave money on the table simply because they didn't know it existed. Here's the thing I want you to take away from this video more than anything else. Talking to a personal injury attorney costs you nothing. Most reputable personal injury lawyers, including at my firm, offer completely free initial consultations with no obligation whatsoever. You don't have to hire us. You can walk away with information and make your own decision. In that consultation, a good attorney will listen to the facts of your accident, give you an honest assessment of your claim's value, explain your legal rights and the deadlines you're working with, and answer every question you have about the process. Come prepared. Bring any police reports you may have, bring your medical records or a summary of your treatment, bring any correspondence you've received from the insurance company. The more information you can provide, the more useful that conversation will be for you. And if you're evaluating multiple attorneys, ask good questions. How many personal injury cases have you handled in California? Have you handled similar cases to mine? How do you communicate with clients? What's your assessment of what my case is worth? What are your fees? Good attorneys welcome those questions. Let me bring this home for you. Personal injury claims are not just paperwork. They are decisions that can determine whether you are financially whole after one of the hardest things you've ever been through, or whether you're left struggling with debt and pain while the insurance company moves on. You are not required to navigate that alone. You are not required to go up against a billion-dollar insurance company by yourself. And thanks to the contingency fee model, you don't have to. So here's my honest, straightforward advice. If your injuries are minor and liability is clear and you've fully recovered, you may be okay handling it yourself. But if there's any real money at stake, any dispute about fault, any ongoing injury or impact on your ability to work, please call an attorney before you make any decisions. If you're in Los Angeles or anywhere in California and you want to talk through your specific situation, my office offers free consultations. The link is in the description. The phone number is on the screen. There's no pressure, no obligation, just information. If this video was helpful, please consider liking it and subscribing. I put out content like this regularly to help people in California understand their rights. And if you know someone who's been in an accident, share this with them. It could make a real difference. I'm Steve Sweat. Thanks for watching, and take care of yourself out there.